delivery of order of judgment.
Petition is dismissed.
I think there are four other connected matters also that has also been. There are four other connected matters also with this matter, Lordship. I think, Lordship, common order has been passed, Lordship. There are other connected matters
Yes,
also,
yes.
Lordship. Deeply obliged.
Item 42. Delivery of orders.
Is dismissed. Deeply obliged.
May I please, your lordship? Item number 16, lordship. I have taken consent from the other side. This matter is before mediation, lordship. And we are expecting some resolution, lordship. That is why this matter may come after a month, lordship. 3 weeks after 3
The
weeks.
prayer of learned counsel for the petitioner and with the consent of the other side list the matter after 4 weeks.
Did we fix, Lordship?
Give a date after 4 weeks.
Lordship, interim order is operating, lordship.
All right. Interim order to continue till the next date of listing.
May I please, Lordship, I wish to mention item number 17, my lord. But when the leading counsel, conducting counsel's mother, my lord, yesterday was expired, my lord. My lord, item number 17,
Yes.
my lord, the mother of the conducting counsel
Alright.
was expired yesterday, my lord. This matter may be adjourned, my lord, for 2 weeks or 3 weeks, my lord. But I think the consent is taken by the from the respondent too.
Due to family bereavement of learned counsel for the petitioner. The matter after 2 weeks
3 weeks, my lord.
or 3 weeks.
Highly obliged, my lord.
May I please, Lordship? I beg to mention item 28, my lord. Kindly, my lord, after a week, my lord.
We have received a case there in this case. Only we have received a case there in this case.
Sir, 1 week.
Item 28. CD is received. The prayer of learned counsel for the petitioner list the matter for 1 week on
Interim may be continued, my lord. Interim order may be continued, madam.
if CD is received then
But the parties, my lord, is going to, my lord, engage senior counsel. That is why, my lord, I have been instructed, my lord.
Sir, Abdullah is not senior enough.
Next week, my lord, kindly, my lord. Obliged.
From one.
Please, your lordship. Lordship, regular bail application, lordship, and petitioner is behind the bar since 13th September. Today is 81 days, lordship. And allegations are under section 329, 3, 118, 2, and 109. FIR is at page 7, lordship. Allegation is that the petitioner attacked informant's elder brother with sharp weapon, lordship.
81 days.
All right, CD.
CD along with injury report.
Hmm?
CD along with injury report.
Short date may be given to 81 days.
Give a date. Short date.
11. Do it
90 days.
11 or 90 will be over.
over 8 corridor.
Obliged.
Your colleague.
Yeah, please. Okay, for a application for regular bail, it is 58 days, Lordship. That is, affair is at phase 19. They were arrested on mere suspicious that they are loitering nearby one ATM and arrested by Bogisto PS. Section is 338 and 313.
FIR is page?
Page 19 with. FIR lodged by one SI Lordship. Page 19 with. Some screwdriver, ATM card, and some Aadhaar card has been seized from them. They are not committing any offense, Lordship.
Also recovered that is suspected to be used in a ATM stolen, Lordship.
Only thing is that 58 days they are behind a bar. The 60 days is the mandatory period, Lordship. There is no specific ground of arrest in forwarding report also. Ground of arrest and region for arrest. That is page 22, Lordship. Ground of arrest is not specific, Lordship. Whatever has been arrested and no notice has been served, Lordship. There is no
Yes, BP, what to do? 58 days.
58 days, Lord. Only allow, Lordship.
Learned counsel for the petitioner. And additional PP decision application under so and so. A perusal of the FIR, it appears that the accused persons were arrested as they were found loitering around an ATM. Near Bogisto police station. And upon search, certain incriminating materials were recovered from them. Having regard to the above, it appears that the petitioners were arrested on suspicion. And in the meantime, they have spent 58 days in custody. And having, it is expected that the investigation will have progressed by now. Considering the same, the prayer for bail is allowed. It is directed that the petitioner shall be released on bail of rupees 50,000 with 10. Dhaka Magistrate. Condition.
Hello, please.
May it please your lordship. Well, here, my lord, that Narim case, my lord, here, lordship has earlier rejected, my lord. Lordship's order at page 26. My lord, here today on the length of detention, my lord, 82 days. Actually, whatever, my lord, on that day, my lord, there was a college function, my lord. Then the boys quarreled among them. Very unfortunate, my lord. One boy died, my lord. Then, but these are, my lord, 19 years, they're all students, my lord. They have, my lord, my lord, some mistake somewhere, some point of time, my lord. Young boys, they quarreled. One died, my lord, and 82 days in custody, my lord. So I pray, my lord, further custody may not be required, my lord. And one person has been granted bail on epilepsy ground, my lord. But that day we did not pray it, my lord. On the rest of the accused, today 82 days in custody. Well, considering the length of detention and considering their age, my lord, 19 years and 22 years, my lord. They will cooperate, my lord. They are a local resident, my lord. They are all students, my lord. So, but it happens, my lord, somewhere, my lord, that, my lord, on that day, my lord, the college function, there was no intention, my lord. Heat of the moment, something happened, my lord, and the students quarreled among themselves. So considering the length of detention only, my lord, the 82 days in custody. With folded hands, I bring, 19 years of boy, that's petition number 2 and petition of 122 years. Both are students of the same college, Nerim, my lord. Having no earlier criminal antecedent. There was a college function, my lord, on that day. There quarrel, my lord. I have took place, my lord. Only on the detention, my lord. I'm praying, my lord.
Yes, prosecution, you should have been able to submit the charge sheet by now.
But yesterday, lordship also rejected after perusal of
Yes, there is here actual submission, it is not submitted. Lordship. Yesterday, one other case was before.
That
the
was
lordship.
AB, my lord. That was AB, my lord. But here, my lord, 82 days, my lord. Only on the length of detention, my lord, with folded hands, I pray, my lord. Any condition, my lord. They are young boys, my lord, they quarrel among themselves. I'm very unfortunate, one, my lord, succumbed to his injuries, my lord. Very unfortunate, but my lord, they will, my lord, learn sufficient lesson, my lord. Their career is also, my lord, academic career also jeopardized, my lord. Now, on any condition, my lord, allow them, my lord. They will definitely reform, my lord. Just have in the exuberance of youth, my lord, heat of the moment, something happened, my lord.
It is available here.
Yesterday was there, Lordship, but it was returned back, taken back or not.
But my materials will be there, my lord. Yesterday,
See-
lordship, materials will be there, my lord, but only on the detail.
Case day has gone to the my Lordship. Already Lordship has gone to the case day, sufficient materials are there against them, Lordship.
Only on the detention, 82 days, and considering the age, my lord, considering their students, my lord, there is no, my lord, intention, nothing. Some heat of the moment, quarrel,
Okay, let me think about it.
lordship. Oblige your lordship. Regular bail, my.
Scan copy, charge sheet submitted.
Charge
Charge sheet has been submitted in the case. Call for the scan copy of the TCR.
I'm obliged.
Five.
Your lordship will find page 10. Lordship. Informant alleged that her daughter lordship was having some affair with one Omid Hussain lordship, and accordingly they eloped. And now present petitioner, he is the lordship friend of that Omid Hussain, and now he is arrested lordship. Page 10 is the affair lordship. Specifically stated about love affair and eloping with Omid Hussain. Now the girl is lordship uploading videos in the Facebook that she is with Amit, and those are not checked by the investigating agency, lordship, but this person was arrested.
As per the forwarding report, my lord, he existed, my lord. And secondly, the guard is major, my lord.
Major girl, lordship.
Third learned counsel for the petitioner learning. This is an application under Spence. As per allegation contained in the FIR, the victim, who is a major, aged about 20 years, has been missing from home, and it was suspected that the present petitioner, with whom the victim was having a love affair, had abducted her, concealed her in an unknown place. Call for the CD.
Yes, my lord.
Call for the CD, having regard to the fact that no role has been attributed to the present petitioner in the FIR, provided that the petitioner so and so be released on interim bail of rupees 20,000 with one security to the satisfaction of the learned Elaka magistrate. List again on
18, 12.
Obliged, lordship.
This is the 483 application, let's say, FIR at page 16. Look. Allegation is that the petitioner has been working as a supervisor in a warehouse wherein the stock of some chemicals has been stored, and that some 1,330 bags are missing. So therefore, only allegation is since the petitioner is the warehouse supervisor, he know everything. But nothing material has been recovered from the petitioner side, and nothing incriminating material about his bank transaction has also been seized. Nothing has been found. Lord. He has been arrested on 16/6. FR page 16.
You are the manager of the warehouse.
No, I'm the supervisor, and
What's the difference?
he is doing the duty for roster wise. In morning shift, he has present from 7 to 11, then from evening 3 to 7. In between, the key remain with the official of that company. The office of the company is also situated nearby to the warehouse. And as per the forwarding report, the ground of arrest, because he is the supervisor, therefore he has been arrested. Lord. So that is page 21. Lord.
Resolution of the case that is necessary, my lord.
The father of the petitioner is advanced stage of cancer, Lordship, and the minor daughter of the petitioner is also 2 months old. She is also suffering from illness. Lordship. The warehouse key remain always in the office, Lordship. That is the difficulty, Lordship. Nothing has been found from the petitioner. He has been interrogated in 5 days police custody, Lordship.
Any recovery?
No, Lordship. Nothing, Lordship.
My lord, reveal from the case diary, my lord. This is from Tinsukia case, my lord. Lordship may fix a short date, my lord, will produce the.
When was he arrested?
Arrested on 16/11, Lordship. Only allegation because he is the supervisor. It is an admitted fact the key remain with the office. The office is situated nearby to the warehouse. For a single person, 1,330 bag removal of that much quantity of a chemical is not possible for the petitioner also.
That is why the
If
case
that is
diary
happen,
necessary.
something happen.
It may not be possible alone, but you may be in concert with other.
There is nothing has been
All the
found.
others may also. What about the others who are in charge of the godown? Have they been?
No. The office is nearby, Lordship. That is the difficulty. And the key remain with the office. For morning shift duty, he present from 7 to 11, then evening shift 3 to 7. And the remaining, and the rest of the time, key with the office. And after 5 days custody, police has not sought for any further police custody. Lodge.
All right, when? 8.
Let the case diary be called for. Lordship may fix it on next Monday, my lord.
8.
8, my lord, yes.
8.
Public.
Application. But a regular bail application, Lordship. Today is 44 days. Because is behind the work. The affair in Lordship, page number 13, vernacular is page number 16. Allegation is Lordship, section 1911 of child marriage. Lordship. There is a lot of affairs, Lordship, but no marriage has been solemnized. He herself voluntarily went to the house of the petitioner. Attend that if marriage is not solemnized, then she will commit the suicide. So for Lordship, notice under section 47, that is in page number 18.
Where is the girl now?
Girl is with her parents, Lordship. It's already been recovered, Lordship. It is statutory 41st already over, Lordship.
As far as my lord, the FIR is concerned, my lord, at that time of my lord, this alleged incident, she was minor, my lord. So whether POCSO has been added or not, that we have to, my lord, go look.
There is no allegation of sexual intercourse.
She was, my lord, ছোৱালীজনী ফুচুলাইনি বাল্য বিবাহ কৰাইছে বৰ্তমান গম পাইছো যে মোৰ নবালিকা ছোৱালীজনীক গান
Yeah, please, Your Lordship. My Lord, this is a pre-arrest bail application, my lord. FIR is at page number 22, my lord.
Page?
Page 22, my lord, vernacular.
Where's the translated copy?
My lord. Page number 15, my lord. My lord, here the accused petitioner number 1 is a plaintiff and the other accused are the pro forma defendants in a suit. And the husband of the informant is a defendant, main defendant in the suit, my lord. And that has been stated in the FIR itself, my lord. Now, my lord, in the FIR, there is a schedule has been mentioned. That is Patta number 54 and dark number 125. The allegation is that the present petitioners, they trespass into the scheduled land and they tried to dispose the informant.
On the face of the FIR, there is no allegation of grievous injury.
So, my lord, Lordship may kindly say, my lord, whatever he has translated, my lord, I'll just mention one line, my lord. Lordship may come to page number 22, my lord, vernacular. Just down below, my lord. বিবাদীগণ আমার বাড়িতে অনাধিকার প্রবেশ করে পাথর দ্বারা শিল মারে ও আমার একখানা বাসের গৃহর কিছু অংশ আগুন লগায় জ্বলিয়ে দিয়ে already, my lord, burned down, my lord. And what he has translated, my lord, injured and thereafter the accused threw stone and tried to put fire on some portion of our house, my lord. That is why, my lord, while the case was registered, my lord, it was registered under section 326G, my lord. This punishment is up to life, my lord. And all the, my lord, petitioner, my lord, they are FIR and accused person, my lord, except the, my lord, 13 and 14, my lord, they are not before this honorable court, my lord. Otherwise, all the, my lord, FIR and accused person, my lord.
Yes, what are those pictures you are carrying?
My lord, I have my instruction to assist my
My lord,
learned
these are
friend.
the, my lord, person, my injured person picture, my lord.
On behalf of two are in the custody, my lord. Two persons are in custody arrested and they are fleeing away, my lord. And the serious causalities, my lord.
My humble submission, my lord, let the case jury be called from, my lord, along with the injury report, my lord.
All right.
May I submit, my lord?
Yes.
My lord, in the schedule portion mentioned in the FIR, my lord will find
It is
that
correct. The land
No,
is-
we find that your translation is not accurate. That is why we are not inclined to pass interim orders
my lord,
for the CD.
may I
based on-
pray for a short date, my
Sorry.
lord?
My lord, short date, my lord, it will be 15, my lord. 15/12.
Highly appreciate.
My lord, I may be allowed to give get a copy from them, my lord, because I may have the right to submit objections.
अपने यहाँ पर xerox को ले लूँगा तुम।
All right, my lord, I will get a copy
I'll
from
give you.
Don't have any statutory right to appear. You can assist the PP.
online.
I cannot direct him to supply you a copy.
Xerox को ले-
I'll get a copy from my friend, man.
May it please your lordship. In the 482 application, your lordship will kindly turn to page 9, the FIR. This is a case where your lordship, the person has actually commented on the post of Assam Live 2024. Just one sentence that the Assam Live has in fact stated that some dangerous scenes in the Delhi blast which were heart shivering. This was by Assam Live. In that particular post, he just made a comment that in spite of the fact that there is a BJP government ruling in Delhi, how such an incident occurred. This was the ground on which the sections your lordship will see 113(3) Terrorist Act, then your lordship 152. This is an act endangering sovereignty, unity, integrity of the country. And then your lordship, there is another section that is intentional insult to provoke. And there is also circulating and publishing false information. First thing is that he did not make any false information. Nothing, just made a comment. How can this blast occur when there is a BJP government in Delhi? Does that make any sense of whether he stated yes, the blast was done very good or something like that? It was not done here. The Assamese part is also annexed here. The specifically he didn't say anything here. That is at page 15. Just one line or two line he stated how a blast can occur when there is a BJP government in Delhi. That is it, your lordship. And they have filed the FIR with terrorist act of terrorism, then your lordship endangering sovereignty. And this was also, in fact, he did not post it. It was basically on Assam Live post. He made one comment on it. And somebody else also commented on the said particular post. FIR has been lodged, your lordship. By a particular, that is the person is, he's the inspector, your lordship, who lodged the FIR.
I think we have granted bail in similar cases.
Yes, yes, your lordship. has-
Only one line, my lord, my understanding is not submitted correctly, my lord. My lord, he has posted, my lord, বিজেপি চৰকাৰ শাসন কৰি আছে দিল্লীত তথাপি এনে ঘটনা কেনেকে ঘটিল
Yes.
যেতিয়া ইলেকশন আহে my lord, this is important my lord.
Hmm.
That means he want to link this my lord incident along with the election my lord. যেতিয়া ইলেকশন আহে তেতিয়া দেখত এনে কোৱা ঘটনা কিয় ঘটে my lord.
Maybe,
That is what
maybe
his intention
that
is
is
not-
that is his view, your
That
lordship.
is his
And it
intention,
is
my
not
lord.
a false
And he has
thing.
made it in public my lord. This is a public forum my lord, Facebook and all this my lord.
So just a comment, he did not make any submission like he is abated or something like that. And this is also not a false information. He just said that there was an election, how a blast can occur in that.
All right, heard learned counsel for the petitioner. LPP decision application under so and so. As per the allegations contained in the FIR, the petitioner had made a comment
In the
in respect of a news item appearing in Ahom Life 24 news channel, and the said comment is as follows. Within inverted, in spite of the fact that the BJP government is ruling in Delhi, how such an incident occur? Why do such incidents happen whenever there is an election? আইনত পাবা বস্তুটো। When were you arrested?
Not, this is a AB. And in fact, your lordship, I have been issued a notice to appear on 10th of December.
It is submitted
So
that
I'll appear, your lordship, only
petitioner
this
has
protection may
been
be.
issued a notice. The section 35,
Yes,
35 months.
yes.
3
And it is now
BNSS
on 10th of
by
December.
the IO for appearance on 10th of December. Having regard to the above, of the allegations, provided that in the event of his so and so is done, re-arrest bail is 50,000 with one security of like among satisfaction.
My
of the-
objection may be recorded my lord in interim my lord. I do.
Oppose the prayer for re-arrest. Further provided that the petitioner shall cooperate with the investigation. Try to witnesses or hamper the investigation in any manner. It is,
Obliged, your lordship.
812 and 81.
no, we are disposing.
That a case CD may be called for my lord.
What will we find there?
Whatever may be my lord, but
What is the necessity?
Stated what is. There no
The lordship has already given interim my lord. Let the city be called for.
Well, I have passed the order.
dispute.
Please, your lordship. We arrest Will Yosef. The allegation against the petitioner is at page number 11 of the FIR.
registered on 3/11/2025. It is humbly submitted that in the last few days, the accused person, Sri Babul alias Chitranjan Gogoi, had harvested approximately half bighá of paddy rice. Lordship, since few days back, the FIR is registered after harvesting the rice belonging to the land of Hopeswar Gogoi, that is us, and also cut down the bamboo grove and took it away after unlawfully entering our bamboo grove. As soon as my father Khogeshwar Gogoi had begun to ask about why such acts were committed, Sri Babul alias Chitranjan Gogoi, along with his son Sri Pranab Gogoi, attacked him with a masked. As my father attempted to bend away, the blow struck his shoulder and arm. As a result, Khogeshwar Gogoi has been seriously injured. Lordship, the bare perusal of the FIR reveals that it is filed very casually. No date, no place, no timing is mentioned when the alleged offense occurred. Lordship, my stand is that the complainant and his son are engaged in manufacturing of local alcohol, Sulaimor, and it is a conflict held between themselves to cover up, to overcome the grudges with the petitioner. We are own brothers, Lordship. The petitioner and the victim are own brothers. To overcome that dispute, in my petition, I have mentioned that already I have para 4 of the page number 4, para 4, the fourth line. As I approach the circle officer for demarcation. So that is the grudge, the complainant. So to overcome that, he has implicated me in this false case. Lordship, sections are, one is criminal conspiracy, which is trespass, that is bailable, and the another section, section 118(2), is also not attracted in the FIR. Lordship, there is a line in the FIR, when I ask why did you do this, that is provocation and instigation. So when provocation is there, section 122(2) will be applicable. So nowhere it is attracted, Lordship. I'm ready to cooperate with the investigation. Lordship, may put any conditions so that I can appear and record my statement.
Does not seem to be a very serious matter.
Otherwise, was inflicted upon the victim with our lordship.
So it will come with the medical report. No,
That's why it's an anticipatory bill. CD may be called for along with the injury report. His
I'm praying for
Dhemaji district lordship. There was section 118 of BNS lordship. It is attracted as per the contents of. As 118 says, voluntarily causing hurt or grievous hurt by dangerous weapons or means.
That will be confirmed with the medical report only.
That's why
Lordship,
we are asking for the.
interim I'm praying. Till
Lordship may call for the case study along with the injury report, lordship.
till injury report, Lordship, I'm entitled to interim. Since ingredients of 118 is not attracted, Lordship. Provocation and
It says
instigation.
struck his soldier and arm and grievously injured. These are almost like a parroting the legal provision, grievous injured. If there is actually something that would be mentioned in the FIR.
Yes,
that
it is
my
very casually.
something has of this nature has happened. Third learned counsel for the petitioner and learned additional PP. The FIR is that
Page 11 is the translated.
It's 30.
13 is the vernacular.
for the CD. Thing regard to the of the allegations. It is provided in the interim that in the event of his arrest shall be released on arrest bail of rupees of the one surety. Yes. Here before the IO with period of 7 days from today. Again on. Yes, sir.
January loss.
I'm obliged, Lordship.
So this is an application number 482. You will find FIR in page number 15 here also. May I, Samarjit Bora, son of so-and-so residing at Hazirapur Prem Dokapat, Tezpur, hereby lodge a formal complaint regarding the unauthorized disappearance and suspected theft of my vehicle, facilitated by the owner of Rental Zoo Agency. Details of the vehicle, Maruti Suzuki Fronx, engine number 772976, chassis number so-and-so, registration.
Where is the FIR?
15, Lordship, page number 15.
This FIR loss.
Page 15. Here on 15 November 2025, I entered into a oral rental agreement with Zoo Road Rental Agency operating in Guwahati, whose owner is Mr. Tanmay Raj Boroi. Contact details. So the agreement was for rental of my above mentioned car for a period of 2 days, with the scheduled return being there on 17 November 2025. Lordship, the booking was communicated to me by Mr. Ricky Nath with my consent, Lordship. Lordship may kindly appreciate this. On 15 November 2025, Mr. Tanmay Raj Boroi of Zoo Road Rental took possession of my car from Mr. Ricky Nath's residence at Mamoni Reshampad, New South Saronia, Guwahati. On the evening of 17 November 2025, the scheduled return date, I asked Ricky Nath about the car. When Ricky Nath contacted Mr. Tanmay Raj, he requested an extension delivery of date, which we did not agree to. Upon noticing something wrong, I arrived in Guwahati on night 17th of November 2025. Myself and Ricky Nath immediately questioned Mr. Tanmay Raj regarding the car status. Mr. Tanmay Raj then stated that he had rented out my vehicle to so-called Kishore Das without proper verification and the identification of documents submitted by the said person were fake. He didn't even take the driving license. The delivery of my car was done by Mr. Tanmay Raj Boroi at Jayanagar, Thai Aham office, as per his statement. As of time of filing of this report, the vehicle is nowhere to be found, and the owner of Zoo Road Rentals were unable to trace or recover my property. I strongly suspect that Mr. Tanmay Raj Boroi of Zoo Road Rentals have committed a serious offense involving criminal breach of trust, cheating, and possibly organized criminal conspiracy, fraud which has resulted in the theft of disappearance of my vehicle. The action of releasing a valuable asset to an unverified person using fake documents clearly demonstrate negligence, and I suspect it is part of larger fraudulent scheme. I request you to kindly register an FIR immediately under the relevant sections of Indian Penal Code to promote action and trace and recover my vehicle, and initiate strict legal proceeding against the accused, Mr. Tanmay Raj Boroi, and the unknown perpetrator who took the car. I am ready to provide all the necessary documents as required during the interview. Here, Lordship, the vehicle was not taken by Mr. Tanmay by the petitioner. In fact, it is categorically mentioned in the FIR that with the consent of the informant, the vehicle was handed over to Mr. Ricky Nath. And till date, Lordship, neither a single FIR or complaint has been launched against Ricky Nath. Moreover, the informant, Lordship, knows that the vehicle was equipped with GPS. Meaning thereby, Lordship, he had absolute knowledge of the movement of the vehicle. And what stopped him?
GPS can be turned off.
Yes, Lordship, but he has stated in his FIR, Lordship, that on 17th he came to Guwahati, Lordship. On 17th of November, myself and Ricky Nath immediately questioned Mr. Tanmay Raj regarding the car status. He came to Guwahati, but Lordship, the FIR was lodged on 23/11/2025 after 7 days, Lordship.
Yes, understood. This is not smelling very good. CD, yes.
I will.
It is yet to be recovered, Lordship.
Lordship, a short date may be fixed. Well, 12 December. Obliged, Lordship.
Lordship. Your Lordship, pre-arrest bail application. Lordship, the case has been charge sheeted and is under PRC case number 1016/23, and notice has been served by JMFC Hoja, Your Lordship. Although the case is under 376(2)L, that is rape of an disabled woman, However, the attributed section and the facts of the charge sheets are not aligned with the case, Your Lordship.
Scan copy, TCF. City.
Oblige, Your Lordship.
Please, your lordship, my lord, pre-arrest bail application, my lord. FIR is at page 9, my lord. I may be allowed to read, my lord. With due respect, I beg to state that I, Sri Bipul Kolita, is a resident of Sankardev Pot, Jail Road. One of my neighbors, Sri Babu Rai, on 3/10/2025 at around 1:30 p.m. inflicted upon me verbal abuses using slang languages on the suspicion that I was messaging Srimati Junali Rai. Junali Rai is the wife of the petitioner number 1. my lord.
All right, CD. Earlier it was rejected after perusal of case diary.
Hello, please.
Please, Your Lordship. My lord, the sorry, my lord, the FIR is at page 11, my lord. My lord, a particular vehicle of the my lord petition is the owner of the vehicle, my lord, that purchased it from my lord, another person, one Madhav Tai, and he had lent out this vehicle to one Vikas Das, my lord. Now, this my lord, vehicle was found by some people, my lord, to be my lord, the persons in the vehicle, my lord, were feeding jackfruit to some cows, my lord. And they were intercepted, my lord, and they were questioned. And the allegation is, my lord, they were trying to steal, my lord, some of the cattle, my lord. The basis of which, my lord, this case, my lord, was registered, my lord, under section 3032, my lord, 62, and my lord, 62, my lord. Totally based on, my lord, apprehension, my lord. And my lord, I am the owner of the vehicle. In fact, I had purchased it from one Madhav Tai and given it to one Vikas Das, my lord, for, my lord, running the vehicle on hire. Initially, I went to the, my lord, police station, my lord, I had cooperated, my lord. Now they are again asking, my lord, my presence, my lord. That's why I'm before your lordship, my lord. Mainly on suspicion, my lord. In fact, they say that only, my lord, allegation is that these people in the vehicle were seen, my lord, feeding jackfruit to the cows, my lord, on the road. Villagers, so not fine.
So, as per the FIR, what is the offense actually?
So they try to
Huh?
eating the cows with.
Only thing seen is they're
Were
feeding
the
the
cows in the vehicle or were they enticing them with jackfruits?
They try to take the cows by feeding the
But petitioner is the owner of the vehicle. He was
Yes.
not present on the spot.
Yes, sir.
Learned counsel for the petitioner and learned it is an application under so and so. As per the FIR, paragraph 2. And it is submitted that the present petitioner is the owner of the vehicle. Question. And he was not present at the at the relevant time. Had no knowledge. To the I did that in the interim event of his arrest. One surety. Corporate.
Oblige, Your Lordship.
It is, sir.
May I plead, your lordship?
I'll come to that.
Page number 10 is the translated copy of the FIR. I read.
Who are you?
I am Adil Haq. I'm a driver actually, and I used to bring all these things at times. I am not related to this particular case because I get some money if I give this type of thing, but I am not involved in this particular case. Both the vehicle, the truck stolen from the police custody was recovered from Babul Ali. He was arrested. Truck was also recovered on that very date. The crane was already taken, and the driver of that crane, Babul
Without your
was,
connivance, it could not have happened.
but I am not there.
City may.
Only mayor suspicion is there against me.
All right, we'll have the CD only.
Yes, yes. Protection may be given.
Not at all.
16th will be fine for me. 16, 1/6. Publish.
Wait, please, your lordship. Lordship, the present petition has been filed by the directors of a company praying for the quashing of the summons and the order issued. Now, your lordship, just this morning, we have filed a fresh petition on behalf of the company seeking for the quashing of the entire criminal proceedings against the company. So I'm praying that both the matters be heard together on any date next week, your lordship.
We have filed an affidavit in this case or a separate case?
No, we have filed a fresh petition on behalf of the company.
Please, your lordship. In this case, this matter has already been listed number of occasion in this court also. And on the last occasion, lordship has given an observation to them to appear. They have come for quashing of this summon that is at page number 65. That is issued under section 61 and 244. Now, after the company has gone into IBC, under resolution plan, they have purchased it. Now it is their duty to go there and appear as a prosecution witness and say, yes, they have purchased. In the resolution plan, there is no criminal liability. As such, this petition itself is not pending. It is a mere abuse of the process of law and burdening the court. Page number 65 may kindly be seen, and under section 61 and
Even to come to that finding that it is an abuse and a burden of the court, we have to take a lot of burden.
Sir, lordship, that's true.
Even while arriving at that finding.
But on the last occasion, your lordship has said and asked them to appear and give a prosecution evidence.
Your lordship, I'm just requesting
Liability
them.
does not arose.
Anyway, similar case has been filed, let us have it together.
But when there is no criminal liability, resolution plan itself says they have attached the resolution plan. It is there. Page
No, we are not on marriage. What is the submission now? Submission is that in connection with the present case, they have filed another application for quashing.
Then they could have withdrawn it, or either lordship can dismiss it.
Your lordship, may kindly.
It is
both
not
petitions
maintainable.
any day next week, your lordship. That's my only prayer for today.
Because it's, order will speak the truth. It is pending.
All right, right now I am in a mood to take a sympathetic view of learned junior counsel appearing for the petitioner. So let's have it on when. It's submitted by learned counsel for the petitioner that a separate criminal petition has been filed today in connection with the same matter. Hence, list this case along with. It has been numbered
We have the filing number, your lordship. We'll have the registration.
with criminal petition. Give the filing number.
Yes, your lordship.
On
Any date next week, your lordship. Highly obliged, your lordship.
Much obliged.
Please, your lordship. My lord, this is a shown case, my lord. In the main case, my lord, today, my lord, that was listed in the court number 22, item number 5. The petitioner is allowed to go on bail, my lord. This is the main FIR, my lord. There is a subsequent FIR, my lord. On 18 November, my lord, these petitioners, they were. Target this, main case, it is shown as. It is shown as. Actually, my lord, they were celebrating, my lord, this Zubin Bard anniversary of Zubin.
This is in connection with which case?
My lord, both two cases were registered, my lord. The first case, my lord, that was listed in the court number, my lord, 22, item number 5, my lord. That is-
Today?
and indeed, that case, my lord, today, his lordship has granted bail, my lord, in the motion stage, my lord. And this
Why
is.
didn't you take this case
The
there?
case before your lordship is the Sona's case, my lord. There is the second case, my lord. Lordship go to both the FIRs, my lord. And my lord,
What is the name of the
Amulya Saikia, my lord.
Amulya Saikia?
My lord complainant, my lord. Next day she was called to the, my lord, police station in this case, my lord. And police has directed her to lodge this FIR. She provided the medical, my lord, documents of the, my lord, victim, my lord. I want to place this before. It was a simple injury, my lord, lacerated injury, my lord. And sworn arrest is only on 27/11, my lord. Admittedly, my lord, he was drunk. There was, my lord, they were celebrating the birthday of Zubin Garg, my lord, late Zubin Garg, my lord. Then there was some altercations, my lord.
One thing I have not understood, my lord, if he has been shown arrest, my lord, how he has been apprehended by the public, my lord.
No, he was not apprehended by the public. Actually, he was picked up by the OC. All persons who were drunk, my lord, several persons were taken to the police station. Others were, my lord, allowed to go. But these persons shouted in the police station. So his sister comes, he was severely beaten up. Then, my lord, sister tried to resist the police. Then, my lord, the first FIR has come. He was arrested in that FIR. And subsequently, my lord, any police has managed this FIR, my lord.
Case number 14, my lord, was got by the public on that day itself, my lord.
Yes, if that is there, my lord, then first FIR lodged by the police, lordship, kindly see, he was picked up by the OC, my lord. Two versions, my lord.
See, you were granted bail in respect of the first case.
First case.
This is shown arrest.
Shown arrest. Lordship, case before lordship is shown.
is another incident, definitely.
No. Actually, my lord, the first incident, the shown arrest case, my lord. Actually, they were celebrating in the, my lord, 18th field of North Lakhimpur, my lord, Zubin Garg's birthday.
Case number 17, my lord.
Yes.
Case
Order.
number 17, wherein, my lord, he has been shown arrest, my lord, in this case, my lord.
Because
That, my lord, when the public has got him red-handed, my lord, on that day itself, my lord.
actually, my lord, the case before your lordship, in that case, my lord, informant's husband, brother, informant's brother, and the petitioner, both were drunk, my lord. There was some quarrel between them, my lord. Then police came, picked up the petitioner and his associates, my lord, to the police station.
Anyway, my lord, in this case, my lord, there are materials, my lord, because this person is injured by him, my lord. So let the case diary be called for along with the injury report.
My lord, already 12 days in custody, my lord. I placed the, my lord, medical documents of the victim, my lord. That is a simple lacerated injury, my lord.
Yes, all right, CD.
Then, my lord, very short date, my lord. Unnecessary he is in, my lord.
10, my lord.
10. My lord, before that,
They were in drunken condition, so detoxification requires 21 days minimum. It's only for 12 days. পিছত দি দিব।
Well, along with the, my lord,
10, 12.
then along with the injury report of the, my lord, victim, my lord.
Call for the CD and the injury.
Sometimes it doesn't come out.
Please, your lordship. CD was called for. I am behind the bar since 86 days. This offense, Your Honor.
Case study not received. Take instruction, Lordship.
Lordship, it is third time Lordship, CD not received. Kindly consider the length of detention.
Matter may be fixed day after tomorrow, Lordship.
Two crores.
FIR, I am not FIR name,
Who are you? What is your name?
Jahangir Ali.
Is the FIR name accused?
No, Your Honor, page 13, Your Honor.
Huh?
Page 13, as for. Page 13, FIR at page 13, Your Honor. Only suspect.
Kindly come to page 18, Lordship.
Hmm?
Kindly come to page 18 of the petition. Order of the trial court, the second paragraph, Lordship. Muhammad Jahangir Ali was arrested on 8/9/25. During investigation, rupees 3,18,000 cash recovered from the house.
Already day after tomorrow. Day after tomorrow is what? That is Monday. 86 days. Then
90 days will over, Your Honor.
90 days will be over.
After tomorrow, Lordship.
Tomorrow if possible.
Day after tomorrow. Today is
Can it be on Lordship on Thursday?
Thursday.
Lordship. Highly obliged.
Wait, please, your lordship. Please make an effort to get the CD Thursday because unless it is there, we'll be left with no option.
My lord, here my lord, petitioner is behind the bar for more than, my lord, as on today, my lord, 85 days, my lord.
You received a case diary.
Received.
Not received.
My lord, here, what happened, my lord, the petitioner, my lord, here, my lord, he was suspected to be in a conspiracy, my lord. He was not involved, my lord, he was in possession of a mobile phone, my lord.
Where is the forwarding?
My lord, forwarding report, my lord, your lordship finds case, my lord, 8/16, my lord. My lord, in the bail decision order also, my lord, what happened, my lord? Her boyfriend was involved in
Oh,
a, my
this
lord.
is 103.
My lord, her boyfriend was in.
How many days?
85 days, my lord. And she is college going student, my lord. 19 years old, my lord.
Already Thursday. Can you get?
Thursday, Lordship. Thursday.
CD not received list again on Thursday.
Obligement.
Right.
After some days, my lord. You will to YouTube, man.
This one to do same.
Item 23.
Yes.
Thank you, Mr. Lordship. Azhar is at page number 12. Petitioner was arrested on 18/9. Today's Lordship, 75 days Lordship. And petitioner is a driver. Some unknown person hired his car until they lift them to the from 13 mile to Nongpo. And his car is also seized by the police Lordship. And all the accused person has already arrested Lordship. Some are also
Page 17, Lordship. Paragraph, round number 3.
forwarding report is page number 16.
Please here. Yes, what is the implication is there?
Accused number 2 and 3 is before your lordship, and there are sufficient incriminating materials against the petitioner. That
Sufficient means victims has implicated.
themselves implicated. The complainant as well as the accused persons, lordship. They have admitted. Statement of Noor Muhammad, that is in item 23, accused number 3, and state Bijoy 24, accused number 2, and all other statements of the sufficient incriminating material.
Were the petitioners in this case? Nur Muhammad.
Then one Bijoy also. Joyful, thank you, and at the rate Bijoy. These are witnesses are all.
Yes, stay somewhat this.
Lordship, my prayer is that Lordship, all the material is already recovered, Lordship, and today is 75 days, Lordship. So all the accused person is also arrested, and investigation may be complete, Lordship. So
Heard Learned Counsel for the petitioner.
maybe consider Lordship detention of the parent, Lordship.
Application under so and so as per allegations contained. Here. 16 or two of history. Upon perusal of the CD. I find sufficient incriminating material of the offense. Right, period of detention of 75 days. Hence rejected. At this stage. Same order. 21, 22. Which one?
44.
44. 44 is also same.
Yes.
Same order.
This kind of charge sheet submitted.
Met your lordship, Fathers. Second time, earlier lordship rejected page 19. 29 years, God, my lord, it appears that consented party, if it is correct, my lord. So I am only on the length of detention. And if charge sheet filed, my lord, I think nothing remains to be investigated. Your lordship order is page 19, order dated 10/11/25. Seven days delay in FIR. Only my lord, further custody is required or not, in view of the latest, my lord's completion.
Let us have the PCR because the allegations are of such nature.
That's true, what I'm telling. What date, my lord, it is here, huh?
As per learned lady,
Comes up.
charge sheet has been submitted, right, CS number.
Case number of chip 194/25 dated 29/11/25.
Call for the scanned copy of the
Which code?
TCR along with CD.
Come.
Is again on.
Some code.
Binjo.
From Amingo. Amingo. 9 December. All right. I'll pay the bill. Oblige.
Lordship, the matter may be taken after some time. My senior is in another court.
We have received the case then.
Okay, after some time.
We have not received the case, right, lordship.
And appears CD not received. List again
Yeah, interim, lordship.
after 3 weeks. Remodel passed earlier to till the next date of.
Ask about a matter for the day, Lordship.
Interim is there, lordship, CD not received.
They did not receive list again on so and so. Remodel passed earlier to continue.
Well,
Petition of MPR lordship, petition item did not receive.
We are all interim, your lordship.
All right. Same order.
Oblige.
We have received the case diary, lordship. Statements of the petitioner is not in the case diary, lordship. So we have to send back the CDN for updation, lordship. It is an interim, lordship.
Updated CD is received, but same is not updated. Hence, send back the CD with for
Can I-
resubmission after updating the same interim order passed earlier to continue the next date. Right, none appears for the petition. Updated CD.
Yes, CD received.
Appeared and his statement has been. And the interim order may make absent.
Some fake currency notes were recovered from one lady
Yes, Lord.
who wants to deposit the fake note in the CSP center. Later on, he was trying in a shop, he was trying to buy something by depositing the five fake notes. As she was arrested by,
That was the lady.
yes. As
Now,
per,
what is this Mokbul Hussain?
when she was court presented, as per her statement, she has stated notes was provided to her lordship by this petitioner lordship.
That is the only
Only
statement.
much. He has stated that he has taken 10,000 rupees from the lady, Lordship. He has returned the money, but one day, the day after, he heard about that. She has deposited some fake transfer and arrested her. Lord. That is his statement, Lordship. And notes were recovered from that lady, Lordship. And
But there is, that means there is no imputation of knowledge that he was
yes,
circulating fake currency. It may happen also.
Lordship. And FSL report is positive. That is
Positive regarding
Lordship. Only sir, his statement is that 15 nagat বাছনি খাতুনৰ পৰা মই টকা ধাৰ লৈ লোৱা 10,000 টকা দিওঁ তাৰপিছত গম পোৱা যায় ফেক নোট দোকানত চলাবলৈ গৈ তাই ধৰা পৰিছে। That is his submission. He appeared in statement recorded, Lordship.
is our order dated 17/9. 1, 2. Four. TDS called for has been received. Of the CD. Found as would impute knowledge the present petitioner as regards fact that 5 numbers of rupees 500 denomination, bundle of rupees 10,000, which he handed over to the fake notes. There are pursuant to granted by this court the IO, and his statement has been considering the aforesaid facts and circumstances, the custody. The prayer for of interim clearance bail dated in 9/25 is hereby made absolute on the order bill number B and C. And allowed accordingly. Bring back the CD.
Hold
May I please your lordship, this is 482 application, my lord, under section 318(4) and 336(3), my lord. Punishment of cheating and punishment of forgery, my lord. And my lord, on Pranab Jyoti Pegu, my lord, he has informed that I have faked a divorce order, my lord. And nothing has been seized from my position, my lord. And my lord, I am an assistant professor of Borpeta College, my lord. I have a relation with a Nirmali Dole, my lord. I have met her in 2018 and gradually we become close after her divorce in 2022, my lord. This Pranab Jyoti Pegu, he has prepared the FIR, my lord. Pre-planned manner to implicate me, my lord. I want to appear, my lord. Any condition, my lord, I will appear before investigation officer, my lord.
And the maximum punishment is 7 years, my lord, and I have been not issued any so I have not served any notice, my lord, under section 35(3) of BNS, my lord. Otherwise, I would have appeared, my lord.
Basic allegation is regarding forced divorce
Fact
decree.
divorce order, my
Copy of
lord,
the
and decree.
divorce.
That I have not prepared, my lord. I have been plain in a
Will
prepared
prepare your,
my lord.
who else will prepare your divorce decree?
Pranab Jyoti Begu, my lord, he has informed in FIR also. He have informed the Nirmala Dole also, and he have informed the family court judge also, my lord. Only he has informed everybody, my lord. And nothing has been seized from my position, my lord.
You have supplied it to this government.
My lord. I want to appear, my lord, with any condition, my lord.
In FIR of thereafter, Mr. Pranabjyoti Pegu was asked to furnish a copy of the order document. Accordingly, Pranabjyoti Pegu sent her a said order.
So you appear there? Charge has been submitted.
Lordship granted me bail, then only I can appear. Otherwise, I will be arrested, my lord.
Can protect you till your appearance.
In any condition, my lord, I will appear, my lord. Maximum punishments are of 7 years only, my lord.
You want us to see on merit, then we'll call for the TCR. Otherwise, if you appear there, you can do that.
Grant me bail, my lord. Otherwise, I may be arrested.
You're not following.
Lordship may give me
Since charge
protection.
sheet has been submitted, we can call for the TCR then if you are not willing to appear there. We can protect you till your appearance.
My lord.
If that is agreeable to you,
My
we
lord,
can do
my
that.
lord. That will be fine. my
All
lord.
right. Heard. Counsel for the petitioner and an additional PP submits that the charge sheet has been submitted by CS number. So
Lordship.
read for by learned counsel
My
for the
trust.
petitioner, the present direction that the petitioner shall appear before the learned court below within a period of 15 days from upon the event of any application for bail being filed, the same as per law. Till then, provided that the petitioner in the event shall be released bail 3,000 with one share of action of the arresting authority. Fire 15 days from today. Upon expiry of 15 days from today.
See, I have been protected, my lord.
Till 15, next 15 days.
My lord.
CS number 150/25 dated 13/10/25. 151/25 dated 13/10/2025.
Obliged, my lord, deeply obliged.
Lordship, I am in interim lordship. The petitioner has appeared before investigating authority lordship.
Yeah, received, yes.
Case that is, my lord, he has appeared, my lord, personally 35T notice, my lord, and he has cooperated with the investigation. My lord.
Third learned counsel for the petition. Additional PP. Dated 17/10/25. Huh? Third para. Learned additional PP submits that pursuant to interim protection granted. Appeared before the IO and statement has been recorded. The nature of the allegation. Fact that the petitioner has cooperated with the pre-arrest bail is allowed. The order of interim pre-arrest bail dated 17/10/25 hereby absolute. Conditions mentioned therein at bill number 2. Above.
Today we have not received the case anymore.
Lordship, my period for interim protection, your lordship, already 4-5 days already taken my respected friend, your lordship. 33, your lordship. And not fail to produce the CD, your lordship. FIRs. 33, Bishop letter.
I'm sorry, my lord, there's some mistake, my lord, in the. Rishabh Tatar, my lord, what I have submitted, my lord, in this case, Rishabh Tatar, my lord, he is the person who appeared in, my lord. Jahangir Hussain to the Belay.
Hussain has not appeared.
No, my lord. 32, my lord, Sarsi submitted, my lord. Previous one, my lord, Sarsi already submitted.
Whether he has appeared or not, he must have appeared. There was an order.
My lord, it was on interim, my lord.
Yes.
My lord, already scan copy call from my lord in this case, my lord. I had ordered it at 17/11/2025.
So we are on 33 now.
33, my lord, the previous order maybe, my lord. Previous order, my lord. That he has already appeared, my lord, pursuant to the.
Yes, yes. That case, previous case, CS has been submitted.
No, my lord. In the previous case, my lord, where the guard has appeared, my lord. Particularly, my lord, it was mentioned in our petition, it was mentioned as item number 32, my lord. That is, my lord, mistake has been committed.
No, factually, in that case, he has appeared.
He has appeared, my lord. He has appeared, he has cooperated, my lord.
So nothing wrong with the order.
Nothing wrong with the order, but item number will be different, my lord. This is the item number 33, my lord.
I am for 33.
In the
I'm not
previous
following
case, my
you.
lord.
In the previous case, in
Previous case, already
32,
scan copy call for, my lord. Or my lord, this matter may be come up again, my lord, otherwise.
Jahangir Hussain.
Jahangir Hussain, my lord.
This is Rishabh Tater. In Jahangir Hussain,
Harshit submitted, my lord.
Rashid submitted after his appearance.
My lord, Harshit submitted on 2/11, my lord. And he was granted interim, my lord. Yes, 17/10, he was granted interim, my lord.
10 days was time was given.
Yes. But thereafter, my lord, on 17/11, when the matter again.
Agar write into data likhi diyo, subsequently charge sheet has also been submitted. Yes. Now come to 33.
33, my lord, he has appeared. He has cooperated in investigation.
I'm not appearing in this case.
Statement is there, my lord.
Statement is there, Your Lordship, but
Because he was 30.
But in this case, in 33, there is no interim protection.
No, my lord, but my lord, pursuant to the my lord, notice was issued to him, my lord. So he appeared before the IO, my lord, and statement recorded, my lord. So there is no apprehension, my lord, in this.
Third learned counsel for the petitioner. Learned additional PV submits that pursuant to notice under section 35(3) DNSS, the petitioner has already appeared before the IO and statement has already been recorded and he was allowed to go. So what is the point of this now?
Your Lordship, am I allowed to go on bail?
It's not required, my lord, because police has said, my lord, he has cooperated, my lord.
There is no apprehension of arrest, Your Lordship, may kindly.
What is the apprehension? You went to the police, they recorded your statement, they let you go and you say you have apprehension. Under what provision they will arrest you now? After they have recorded you, they would have arrested you then itself.
They have recorded here his statement also, my lord. It is in the case there.
Under the aforesaid circumstances, petitioner cannot have any legitimate apprehension of arrest in connection with the aforesaid case. Accordingly, the petition stands
Closed, Your Lordship.
closed.
Obligers.
May I please, Your Lordship? In this case, I am on interim, my lord. I have appeared, my lord. During the pendency, my lord, search sheet was submitted and TCR was called for, my lord.
TCR received, Lordship.
FIR is on page 7, my lord.
Date of birth of the victim girl was 16/4/2012. Date of occurrence is 18/9/25. She is apparently she's a minor, Lordship, and Lordship.
My lord,
Going
both
to
of
the statement 183, she was implicated that she was forced to go with him, Lordship, in a bike with 2 other boys, Lordship. But
13-year-old.
yes,
my lord, on that evening, my lord, she was returned by.
May I please, Your Lordship? FIR is page 9, madam. The Sub-Inspector of Police of Sulong Outpost was an FIR stating that he got the information secretly that one FIR name accused person, Majibur Rahman, is involved in some illegal activity, and thereafter the informant along with the staff, my lord, conducted charge operation the house of that said accused person. But there 3 numbers of HP machine was recovered and 2 cartons of fake Indian currency and, my lord, 1 bundle of printed Indian currency note and 1 bundle of white paper and on Oppo mobile phone. These are all correct, my lord, recovered from the house of FIR name accused person, and he is in jail, my lord. Now the present petitioner, my lord, who is not named in the FIR, and he has some relation with that arrested accused person in this way. That arrested person, my lord, he was a mason, my lord, by profession. And in my house, my lord, he was working as a mason and my building construction is going. And perhaps it's suspect or wrong information, my lord, the police also charged me, my lord. On that apprehension, I have filed this case, my lord. So kindly examine the case diary, my lord. Very unfortunate, this person is never, my lord, no criminal incident in his life, my lord.
In the FIR, my lord, the allegation is against the Mojibur Rahman, my lord. And from his house, my lord, printing machine, then my lord, one carton printing paper like fake currency note, bundle of printing papers, fake 500 currency note, then one bundle printing paper, then one mobile phone that has been seized, recovered and seized, my lord. Now, my lord, the arrested accused, my lord, he has implicated this person, my lord. Setting that, my lord, he used to take his house, my lord, for my lord, preparing this fake currency notes, my lord. And even the witnesses also interrogated, my lord. They have also stated that, my lord, person, my lord, come to his house, my lord. They have, my lord, heard some noise of, my lord, some machine noise, my lord. But what was inside, that is what they do not know. My lord, the person has implicated him, my lord.
I think only for save himself, my lord, such a statement has given, my lord. In fact, from the petitioner's house, my lord, nothing was recovered. The unfortunate, my lord.
Yes, because your place of operation is different. You're not doing it in your own house. I don't think this is a fit case for pre-arrest bail. Had learned counsel for the fifth and additional PP. This is an application under so and so. The allegation contained in the FIR is that on 30/10/25, the informant, paragraph 4 of the bail petition. An accused has been arrested.
That accused has been arrested, my lord. From whose house might was recovered.
The main accused in this case has been arrested. Perusal of the CD. Learned PP sub additional PP means that there are sufficient materials available against the present petitioner as well. Having regard to the prayer for arrest bail stands reject.
May I please, my lord? My lord, this is a petty case, my lord. The case registered under section 305 subsection A of VNS lordship. This is a theft lordship. And now, lordship, this present petitioner is a lordship. This carrying on business scrap dealer, my lord. And now, as per forwarding report, my lord, the some accused persons, the arrested, my lord, their statement basis, my lord. This present petitioner involved, my lord. And now, this present petitioners not only the 305 subsection A, it is a case lordship 317, the stolen property, the receipt, my lord, not 305. It's a case under 317 subsection 2. And now, lordship, recover articles were recovered, lordship. The one inverter battery, lordship, and 1 liters, my lord, Nerolac oil paint, my lord. Both recovered, my lord. And now, my lord, the Honorable Supreme Court, my lord, this certainty until this judgment, my lord. Page 72, my lord, this judgment, my lord. I have flag marked, my lord. The type of offense, my lord. The offense punishable with imprisonment for 7 years, less not falling in category B and D, my lord. The offense is there in this case, my lord, 317 subsection 2, maximum extent to 3 years, my lord, this punishment section, my lord. Now, this Satyendra Kumar until versus CBI judgment, my lord. The type of categories, the offense with imprisonment of 7 years or less not failing category B and D. B offense, lordship, the offense punishable with death, imprisonment, life, and imprisonment more than 7 years. C offense, special act, and D, lordship, this economic offense.
So this is a
Now-
pre-arrest bail application, isn't it?
Yes, my lord, PRS bail application.
We are
This
only
judgment.
concerned with whether you are entitled to pre-arrest bail. We are not concerned with Satyendra until.
It is clearly mentioned this judgment, my lord. This- No. This Satyendra Kumar until this judgment, my lord.
We are
Can you see?
concerned with Satyendra until here in an anticipatory bail
Maximum
application.
punishment is 7 years.
Punishment is 7 years. Police are entitled to
expired.
issue a notice. If they don't issue a
No,
notice and
no,
arrest
notice
you,
is-
remedy is elsewhere.
And not recovered from me. That's why I'm coming this before this honorable court.
Now, why are we concerned with until now?
And now this judgment, my lord,
That-
no.
that judgment
issue
concerns
51
issuance of
A or
notice.
51 Notice, my lord.
Okay. If they arrest
Will
you without
cooperate, my
notice,
lord.
your remedy is
From-
different.
From my position.
How can we say?
Being this present petition is carrying, running,
They may issue a notice
Fair.
at any time.
at least recovered, my lord, this stolen article, my lord. Will cooperate, my lord.
Charge sheet submitted.
Yes, sir.
All we can do is call for the TCR now. Or otherwise you appear and apply.
Yes, my lord, will appear at least. Protection may be given, my lord. Will appear, my lord.
Till then. Till then.
Before, my lord, this receipt copy of summon, my lord. That's submitted, no? Otherwise, before receipt copy of summon, my lord.
Learned counsel for the petitioner, learned. He submits the charge sheet has already been submitted by CS number.
531/25 dated 27/11/25.
As spread for by learned counsel for the petitioner. Application is disposed of. That petitioner shall appear before the learned court below. Gift of summons. Date fixed by the state court. Upon such appearance, the event of bail application being filed on behalf of the petitioner. Till the said date of appearance. That may be issued by the learned court below. I did that the event of his arrest. Connection with the aforesaid case shall release on bail of security to the section with the arrest.
Deeply obliged, my lord.
21 and 22 are same laws.
I'm sorry, my lord, I was not there on time. My lord, here, my lord, with all respect, my lord. 430, sorry, my lord, bail application, my lord. And herein what has happened, my lord, 2 sections are non-bailable, rest are bailable, my lord. 109, possibly materials as regards 109, my lord, earlier 307 IPC, no materials can be there. And regarding 180 also, 118 also, my lord, grievous are no materials can be there. Here, rice bag was allegedly stolen away. But from our side, we say that it was not stolen away. We lost 2 FIR against them. They lost 1 FIR against us. All exaggeration in all 3 affairs, my lord. Only in my understanding, my lord, with all respect, my lord, possibly injuries, there cannot be any injuries, my lord. Although weapons, name of weapons are there, no weapons were used, only fisticuffs, my lord. With all respect, my lord. This is our case, my lord. And already, my lord, my lord, bail application, 42 days in custody, my lord. Item number 2, my lord. 22, item number
22.
22.
Well, there are 2 matters tagged together, my lord. One, lordship has granted bail. Today's, my lord, first item in this list of series of cases, my lord.
21 is the
And item 21 is on interim, my lord. 22, they are inside for 42 days, my lord. 22 may be taken, if possible, my lord, taken up first, my lord.
Yes, PP.
Injury report. Your Lordship. One person, Nokibul Ali, simple by blunt weapon. One is Salam Malik, which is simple by blunt weapon, Lordship. Lordship, witnesses said their confrontation took place between altercation took place between two parties for a stolen of a rice bag, and on that heated argument, assault was there, Lordship. That witnesses said ended, but item number 21, he was present there. No materials against that piece number 1. As part of item number 22, Bijoy Roy, he was there and confrontation took place between the parties. He was assaulted.
And regarding the looting of money, anything is there?
That is, witnesses stated that we have not seen that looting of money.
Order dated 13/11/25, huh? There are 1, 2, 3. As called for has been received. Additional PP upon perusal of the jury report submits that the injuries are simple in nature. Further submitted that with regard to the allegation of an amount of rupees 3 lakh from the shop of the complainant. That's specific material as per eyewitness accounts. The above. The therefore bail is the order of interim bail in 11/25 by made absolute on the same condition. Well, item 21, 22 add kori interim to no. Yeah, and having regard to the period of detention of about 44 days.
42 days, man.
42 days to add kori. Is done bail of the Agotur. Interim bail of 20,000 subject to satisfaction.
Highly obliged, my lord. Obliged, my lord.
Is Milord service report is awaited. In fact, Milord steps were registered steps were sent on 14/11.
Respondent 2.
Number 2, Milord.
The service of
One,
respondent number 2 is not yet complete. Await list again after 2 weeks.
Only thing, Milord, the next date is fixed. Interim must be considered on the returnable date, Milord. The next date is fixed on 17/12. Can it be a Milord prior to that, Milord?
17/12. 12. Before 17/12. Okay.
May I please your lordship. But here, my lord, they have filed IA, my lord, for vacating of this order, my lord, passed by this honorable court, my lord. In fact, my lord, by that order, my lord, TCI is not yet, my lord, called for, my lord. So for adjudication, this interlocutory application, my lord, TCI is, my lord, required, my lord. So your lordship may, my lord, call for the TCI, but.
But here, my humble submission before your lordship, actually 4,000 rupees as maintenance was granted to the mother and child, my lord. Now what happened, my lord, the entire maintenance order has been stayed by your lordship. So I filed the vacation petition. They raised the question that marriage is not a valid marriage. Muslim marriage, my lord, marriage is not valid marriage, but after marriage, my lord, child was born, they live together. That is the finding of the appellate court, my lord, below, the session judge. That you see, the legality and status of the marriage should not be decided in maintenance case. And in the DB case also, even the child illegitimate child is also entitled to maintenance. Now what happened, my lord, a stay has been granted regarding this maintenance. Whole stay.
The
So
trial
my
court-
humble submission before your lordship, what my learned friend submitted, my lord, at the time of showing notice, my lord, LCR was not called for. Now my friends submitting that LCR will be required. Yes, LCR may be called for, but this maintenance order should be interfered with. my lord.
No, my lord.
The otherwise, my lord, how the child will survive?
There cannot be, my lord, part heard.
There is no scope of source of income, my lord. Your lordship will consider.
You are challenging this appellate order of maintenance.
And my learned friend is, my lord, challenging, my lord.
No.
No. I am not challenging. He is challenging.
I have challenged that, my lord. Yes. I have challenged and
Order dated 2/3/23,
lordship. And after, my lord,
by which what was
appellate court
granted?
judgment is, my lord, stayed, my lord. The appellate court judgment is stayed, my lord, not the, my lord, maintenance order by the trial court, my lord. Is by the appellate court.
Wrong submission, my lord. When the appellate court's order is state, my maintenance is state, my lord. Whole order of the state.
The appellate court judgment was against me, my lord. That's why, my lord, I challenged that particular appellate court
Obviously.
judgment. So in that way, my lord, this court stayed after hearing a prima facie case found, my lord.
Expertise.
And, my lord, that is a different matter, my lord, because you will be heard, my lord, at the, my lord, relevant time, my lord. And, my lord, by that order, my lord, appellate
Let us
court
see the appellate judgment.
Yes, my lord. That is, my lord,
Page 129 onwards, my lord.
13/2022, criminal appeal, my lord, 13/2022. And in fact, my lord, by this application, there is no provision to vacate appellate court judgment, my lord. Your lordship may hear the entire matter, my lord. Calling upon the, my lord, trial court record, then your lordship will entirely, my lord, hear the matter, my lord. There cannot be any piecemeal hearing, my lord, to vacate the, my lord, stay order. The appellate court stay order cannot be vacated like this. my lord.
Hearing will not be, but what about the maintenance, my lord? How the wife will survive? What is the purpose of maintenance?
Now, if, my lord,
As child, if child is illegitimate child, supposing marriage is not valid marriage, how that child will survive? This question is to be decided, your lordship.
And that has to be, my lord, on the basis of the, my lord, trial court record, my lord. This appellate court judgment is also on the basis of the trial court record.
That must have been reflected in the judgment on the basis of which it has been passed.
So, lordship may hear entire matter, my lord.
My lord, your lordship
call
will
for
turn to
the
page 150,
trial court
paragraph
records.
36. Entire matter, my lord, entire matter, no problem. But maintenance is to be interfered with, my lord. That is,
If it
stay
is,
order
my
is to
lord,
be interfered with.
If it is decided against me, then it will be, my lord, benefited, my lord.
My lord, I am the wife, live together, child was born, now he is saying no maintenance.
That is your case, my lord.
Yes, that is my case, that is I am
Yes.
submitting.
And that is, my lord, the marriage is illegal, my lord. That is the, my lord, admitted position by the apex court also. How it is, my lord, not legal?
That answer, that has been answered by the court below, my lord. Ability of marriage, it is the duty of the civil court. In DB case and maintenance, status cannot be decided.
Everything is, my lord, on the basis of the evidence, exhibits, my lord. Order was passed by the appellate court, my lord.
And on what basis was the order of the appellate court stayed by this court?
In fact, my lord,
On the basis of any evidence?
my lord, this
If,
court,
if the court can stay, if we can stay the impugned order without the LCR, we can also vacate it without the LCR.
that is there, my lord. In fact, court has, my lord, perused the, my lord, appellate court judgment, my lord, where, my lord, admittedly, my lord, the persons, my lord, they were under age 8, my lord. They did not attain the age of, my lord, marriage, my lord.
The order does not reflect anything as such.
But in fact, in the status, my lord, stay orders, my lord, it doesn't reflect all these, my lord. Because date is fixed after 4 weeks to hear the matter, my lord, issuing notice. And they can, my lord, argue if there is a case.
So why did you not insist on that day for calling of the LCR?
In fact, my lord, I was under impression that, my lord, in the order, LCR was called for, my lord.
After that, several occasions came by, you could have pointed out.
That is there, my lord. Since
Now
they
this
have, my
point
lord,
is raised.
insisted for hearing this interlocutory application, my lord, because in
I-
that event, my lord, record is required, my lord.
Learned friend is very comfortable position, my lord. That is why.
Oh, my lord. And in fact, this appellate order is illegal because there is no disclosure evidence, my lord, or affidavits. Where, my lord, this is the, my lord, guidelines by the apex court. In subsequent orders judgment also, in by this honorable court also, if there is no disclosure evidence, my lord, mentioning the, my lord, assets and, my lord, liabilities, my lord, then it's a, my lord, illegal order, my lord. It's a settled judgment, my lord. This is, my lord, upheld by this honorable court also. There is no disclosure evidence, my lord. Affidavit
The law will come.
by this in the appellate court judgment, my lord.
To the law.
So
will
having
come later
prima
on.
facie found, my
But
lord, this
regarding
court
maintenance.
You are not on the quantum, you are you are on the legality of the
legality,
marriage.
yes, my lord.
So what is the relevance of affidavit?
But yes, but this is the settled law because
As far as interim maintenance is concerned,
in fact, my lord, interim as well as, my lord, the main maintenance, my lord, full maintenance. In both the cases, my lord, this is required, my lord, as per the apex court judgment, my lord. In this case, my lord, there is no affidavit, my lord. And that is the settled position. In that case, my lord, this court, my lord, remanded back the matter to the trial court, my lord, for a fresh case to decide the maintenance, my lord. In that event, my lord, this
which case? Who?
my lord, in our High Court, my lord, there is a judgment by Honorable Court, my lord, Robin Foucault, my lord. There is an order, my lord. To that effect, there is an order of, my lord, family court without, my lord, affidavit, my lord, before the, my lord, learned court below. In that way, my lord, this
In
court,
fact, there is an order passed by this court also, remanding the matter back because affidavit was not there.
yes, my lord.
But in the meantime, maintenance is to be paid.
My lord, that is
Till-
there, my lord. But
because-
matter was remanded back.
They cannot live without eating till the matter is decided by the court.
Only 4,000 rupees granted.
What you are, my lord?
15 and 2,500.
The law is settled, my lord. If you are entitled, then entitled. I have no case. If you are,
Till that is decided, people have to survive.
no, my lord, immediately your lordship can hear, my lord. Any day, my lord, your lordship, if your lordship, my lord, is kind enough to, my lord, call for the LCR, my lord.
Cruel.
PCR, my lord.
Convenience of the court will not be decided by you.
Yes, my lord.
So the appellate judgment has considered all the evidence. Why do we need the LCR?
If your lordship permit me, my lord, I want to submit before your lordship. Appellate court has extensive power, my lord, to consider evidence, facts, etc., everything. But in revision, my lord, if your lordship found that there is palpable illegality, impropriety, then only your lordship will interfere. Because power in appellate court and power in revisional court, my lord, there is some distinction. Entire thing has been discussed
And my
by
lord,
the appellate court, my lord.
the appellate court, what has been discussed by the appellate court, the evidence, my lord. In fact, that is not correctly appreciated, my lord. That is one my submission, my lord. And secondly, it is admitted that, my lord, the present petitioner, my lord, who is the husband, who was not even at the age of, my lord, marriage, my lord. So this is admitted by the appellate court also, that he is not in the age of marriage, my lord.
But as per law, that will also not give you an escape route.
This, there is, my lord, I am having a judgment, my lord, that if you are not, my lord, attaining the age of valid marriage, then there cannot be any relation in the nature of marriage, my lord, under the DV Act, my lord. This is specific, my lord. But everywhere, my lord, a wife has to be a, my lord, a part of the valid marriage. So your lordship, if your lordship kindly allow me, I can place this judgment, my lord. This is the settled law, my lord. Unless there is a valid marriage, my lord, there cannot be, my lord, and in that relation, my lord, relationship, my lord, there cannot be any, my lord, offense, domestic offense, my lord, under section 3 of this DV Act, my lord. Your lordship may kindly allow me to place this judgment, my lord. You know, there has to be valid marriage. Admittedly, my lord, in the appellate court judgment, it has been admitted that, my lord, I am not the age of 21 years of old, my lord. At that time, my lord, I am 19 years of old age, my lord. And in fact, my lord, before alleging marriage, there was a 376, my lord, allegation against me. FI was lost by the, my lord, victim girl, my lord. Then, my lord, this, my lord, fact has been projected, my lord. And there is a, my lord, Nikah Nama also exhibited, that is also, my lord, under inherent contradiction, my lord. In fact, the lady herself is not saying the exact.
Whatever be the matter, you cannot deny that you are the father of the child.
No, my lord, that I will, my lord, place that, my lord, that was not proof, my lord. The contention of that birth certificate was not proof, my lord. In fact, one of the, my lord, PW, he is saying that he doesn't know about this, my lord, birth certificate. She doesn't know. One of the, my lord, witnesses, my lord, their witness. He is saying that he doesn't know about this exhibit 3, that is the birth certificate, my lord. Their evidence, my lord, this is on record. So contents of that birth certificate is not proof, my lord. And in fact, we have denied this. And my written statement has not been denied by them, my lord, any of them, PWs. Your lordship may have it, my lord, under DV Act, my lord. This mandatory requirement is there, my lord. You are to be a, my lord, for a valid marriage, to get this, my lord. To get this, my lord, if there is any, my lord, violation, my lord, there cannot be any, my lord. This relationship in the nature of marriage cannot be considered, my lord. This is the apex court settled law, my lord. And this is already, my lord, in different cases, my lord, this is relied upon, my lord. It's not that, my lord, any maintenance case, there has to be, my lord, there cannot be any decision with regard to the marriage. This is not correct in my humble submission, my lord. There has to be a valid marriage. There has to be a legal status of the wife, my lord. Under DV Act also it is applicable. This is discussed, my lord. Admittedly, the girl was also minor, my lord. She did not disclose it. Before he suppressed that fact, my lord. See. At the age of her, my lord, at the age of my lord, at the time of my lord, this alleged marriage, my lord, she was 16 years old, my lord. He also suppressed this fact.
But if your lordship permit me, my lord, party is Mohammedan, puberty is 15 years. And if after attaining puberty, 15 years, a Mohammedan entered into marriage, it is a valid marriage. There is decision.
My lord, I will also.
So, my lord, there is to be law in both sides. But at this stage, my lord, if my learned friends say that elsewhere may be called for, I have no objection. But regarding maintenance, my lord, your lordship definitely would looked into. That is the thing, whether there is a valid marriage or not valid marriage, there is a difference between other marriage and this Mohammedan marriage.
But there is no difference, my lord.
Under puberty, yes, marriage chapter you have to read. In Mohammedan law, there is a
Supreme Court
separate.
has already, my lord, set aside the appeal. My lord, this was a case of, my lord, Punjab and Haryana High Court, my lord. That puberty is permissible in the Mohammedan marriage, my lord. Then Supreme Court has set aside the appeal, my lord. So this is the latest position. So far, puberty is concerned, my lord.
But what about
DV Act does not insist upon marriage, does it?
Yes.
Is it in the if cohabitation is enough?
Yes, in fact, that is,
Cohabitation is enough, my lord, and he is not
there
denying
is
that.
no
it is not
cohabitation
good
in
sex.
fact, my lord.
Heard
So that I will, my
heard
lord,
learned counsel for the petitioner, also heard learned counsel for the respondent. This is an application. Which is your IA?
My lord, IA number 1030.
This IA has been filed seeking vacation of the order dated 16/7/25 passed in the connected criminal revision petition 252 of 25. The state revision has been preferred by the petitioner challenging an order 2/3/23 passed by the learned session judge Morigaon in criminal appeal number 13 of 2022, whereby the judgment dated 5/8/22 passed by the learned additional CJM Morigaon in CR within bracket CV number 687 of 17 under section 12 of the PWD P Act was set aside and was directed that maintenance amount, inter alia directed that and maintenance amount of rupees 4,000 per month shall be paid to the respondent and her child, their child. While is in the instant case by order dated 16/7/25. The impugned judgment dated 2/3/23. Criminal appeal 13 of 22 paid by this court till the returnable date.
one thing, my lord, they have suppressed one thing, they have received already 34,000. I have, my lord, paid, my lord. They have not disclosed this fact before this court, my lord. They have suppressed this fact, my lord.
Check that.
They have received 34,000 already.
Submission, my lord. They state I come for vacation of the stay. What is the suppression?
They are
That is
saying
not
that we
record-
are not receiving
already.
anything.
That
I have received nothing.
aforesaid
Where is
order
this statement?
stay was
Mayor saying the word will not do.
returnable date, which was after 4 weeks from 16/7/2025, which has long expired. Your stay is anyway gone.
My lord.
Your stay was still returnable date only.
In fact, my lord,
4 weeks is gone.
In fact, my lord, what is the, my lord, procedure of the court, my lord? In fact, this is settled by the apex court also, assuming it is not listed in time, my lord. So that is not because of the client's fault or the advocate's fault, my lord. So that is up to the registry, as and when, my lord, matter is, my lord, listed.
Yes.
So till then, my lord, since IA is not decided, so, my lord, it is automatic that stay will be continued till this matter is decided, my lord. So this is the settled law, my lord. Unless there is a, my lord, reason order by this court to vacate the, my lord, stay order, there cannot be vacation, my lord.
But it's-
We are aware of the settled law.
That
That is
child
why
was born.
that is why we are
Child was born.
that is why we are proceeding to dispose of the IA.
My lord. My lord, what happened, my lord? Child is born, my lord, now abandoned. And the
It is
case is also
judgment
abandoned after getting
and
this
high.
stay.
It is.
It is not
seen
the
that
responsibility of the
learned session judge
council
after due
to bring the case.
consideration. Please take your seat. Passed by the learned session judge. appears that the learned session judge, after consideration of the evidence on record, had passed the impugned order, including an order for maintenance of rupees per month for the respondent child. Para, having heard learned counsel for the petitioner has that in the payment of maintenance amount result in pending the disposal of the result in vagrancy of the till the matter is finally decided and is in need of finance for survival as well as the survival of the child. You stay. Vacated the is the connected criminal revision for hearing on.
My
Give a
lord,
date.
your lordship may have, my lord, fixed date, my lord, earlier
Yes, that
date.
is
my
what
lord.
I'm asking. Give a date.
Your lordship may have it, my lord, in the month of, my lord, December, my lord, in the last part, my lord. And your lordship may
Give
call
an
for.
agreed date.
Yes, yes, your lordship may call for the TCR, my lord.
Call for the TCR.
And deeply obliged, my lord.
In the main appeal, in the main criminal revision. Give a order passed in IN number so and so. Call for the TCR.
I'm deeply
Is
obliged.
the matter for hearing on in December.
I'm deeply obliged, my lord. Obliged, your lordship.
One two one four. Oh, it's got them.
Yeah, please. So CD was called for yesterday, it was fixed for CD. I have provided the bail application yesterday that was passed by the lordship where 49 days custody was being taken into consideration and he was being allowed to go on bail. And anticipatory bail out of the same FIR has been also been allowed by the coordinate bench. I have annexed the anticipatory bail order at page 15 of my application. And the DA application that is considered for 49 days I have provided yesterday. And herein the petitioner is behind the bar for 54 days as of today.
Is anything against this fellow, Nazrul
Yes,
Islam?
yes, my lord. See, actually, this person, my lord, he works under Pallavi, my lord. Pallavi Soikia, my lord. Pallavi Soikia is the. my
He is
lord,
also a volunteer.
He is also educational volunteer, my lord, and as per my lord, his statement, my lord. He has stated that, my lord, he collect money, my lord, and he was transferred to Pallavi Soikia, my lord, for to purchase some, my lord, educational equipments, which are actually, my lord, is supplied by the government, my lord. They collected money, my lord, from the other, my lord, educational volunteers, my lord.
We have admitted that fact, your lordship. We have worked according to the direction of the Pallavi Soikia and we are working under her. So we had no idea what she has to.
Case of conspiracy and other.
If an order dated 28/11/25. Same order.
Obliged, your lordship.
Yes, Mr. Sharma, you want to burden us before the vacations?
On a very short point, my lord, I'm only on the seizure part.
Yes, yes.
a violation of the section 100, 4 and 5 of the CRPC. That part. Here what my lord, there was a allegation that 310 grams of heroin was seized from this lady, my lord, who is in jail for the last about 2 years, 10 months. And prior to that, she was also arrested and she was in jail for 1 month. However, after perusal of the CD, she was released within a month. So it is at almost my lord, 3 years she is in jail. Now, my lord, the allegation that the alleged drugs was recovered from her body and from her purse, and that was seized. Now, we'll also kindly come to the evidence part. Schedule 1, 2, 3 are independent witness, they have said. Page 21. My lord, you'll also will have to go through the LCR. Schedule 1. Utpal Rajkumar is a witness, my lord. His case of Sonari. Sonari PS. There is a name.
And here's your lordship, I'm just.
Going through the judgment, evidence is reflected there. What do you want to show?
My lord, there was no witness of seizure. What was seized and nothing, nobody, even the IO doesn't know what was seized. We'll also kindly see. Report is Schedule 1.
Schedule 1. ইয়াক চিনি পাওঁ, আছামিক চিনি পাওঁ, 2 বছৰ আগৰ ঘটনা, সোণাৰী টাউনৰ গোহাঁই হোটেলত ঘটনা হৈছিল, তাত মই চাহ খাই আছিলোঁ, তেতিয়া পুলিচ আহিল তালৈ আৰু মানুহগৰাকী ধৰিলে, আমাক চহী কৰিব দিছিল, মানুহজনীৰ পৰা কেইটামান বস্তু জব্দ কৰিলে, আমি জব্দনামাত চহী কৰোঁ। ক্ৰছ পাৰ্ট হোটেলখনত তেতিয়া আৰু কাষ্টমাৰ আছিল, জব্দকৃত বস্তুৰ পেকেট খুলি দেখুওৱা নাই, কি জব্দ কৰিলে নাজানো।
And second. Then PW2, my lord.
PW2. I do not know the informant and the accused persons. So. The third line, police asked us to put signature on a paper. Something was seized. The cross part, I have Betelnut shop. Police came when I was about to open the shop. Police entered Gohai Hotel. Customers were there. Nothing has been shown to me by police. I did not see from whom the materials were seized. Police asked me to put signature and I signed. One driver was also arrested. I specifically do not know about the incident.
3, independent witness.
Now PW3. I do not know so. One lady was arrested from my hotel who was a customer of our hotel. Then cross part. I am the owner of the hotel. At first, I was not at the hotel. At that time, there was 6-7 customers were there. One packet was shown to me by police. Police told that it was seized from lady customer. My wife sits at the hotel. I do not know anything more concerning the incident.
Wife was not made witness. And the wife was not, the hotel owner was not made witness.
PW5.
4.
4. Constable.
Priyanka nahi. Sai.
ऐसा इतिहास है। Yeah.
Read, lordship. Yes, sir.
PW4 says, my lord, I know the informant and all accused persons. The incident occurred on 6/9/2016 and at that time I was posted as Sonari PS on that day. Amarjyoti Bailung, Constable Nilamani Kalita, WPC Priyanka Gogoi, and myself went away in search of a group of drug peddler. As we received information near my hotel, Borahi, we found 300 grams of brown sugar from the position of the accused Gitar Baniam. After search by a lady constable, Bailung took them to police station. Other accused persons were accompanied by the lady accused. He is the my lord SI police official witness in the cross. We had 3 other staff. Amarjyoti Bailung was on lead. DSU went to place of occurrence after we apprehended them. Other customers were there with the owner of the hotel. I did not record anything. I neither seized anything. The person who filed the FIR, my lord, who went there to arrest and seize, he says I didn't seize. He's the official witness. Not a private person. Then my lordship kindly come to Schedule 5. He is a constable. A constable.
Who is the seizing officer?
And apparently it appears to be by
Six, Lordship.
PW6.
Happens to be the informant.
PW6. What is the date of seizure?
Date of seizure is 6/9/2016.
In 2016. What is the date of production before the magistrate? 52A is complied.
No.
52A is
52 is not
complied.
complied.
52A in
No.
NPS. Production before the magistrate. Preparation of inventory.
That is exhibited, Lordship.
The whole bulk is exhibited.
Yes, seizure list is exhibited.
No, not seizure list. What about the bulk of the drugs? Either you exhibit the bulk of the drugs or you follow 52A.
$42, $52, nothing applied one.
When was it seen by the court?
That is on 20, extract copy of GD entry, that is on 28/11/2019. Thereafter, Lordship,
No, date of seizure is?
Lordship, I'm coming to that. Date of seizure is, Lordship, 6/9, Lordship.
6/9. And when was it seen by CJM or magistrate?
That is on 28/9,
28/9.
Lordship.
And in between this period, where was this? Any Malkhana receipt, godown receipt, register produced in evidence? Any evidence to establish the chain of custody?
Lordship, to that regard also, they have not put any suggestion.
No, it is for prosecution to establish.
Yes.
So no chain of custody, whether section 42 is complied with
Yes.
intimation to superior officer within 72 hours. Does the IO say that?
IO is my
Seizing
lord.
officer?
Examination that he said that no written.
PW8, my lord.
Yes.
In the cross, when I see.
No intimation to senior officer, next superior officer.
Intimation was done, Lordship, and accordingly,
Where has he said that?
intimation was done. I'm coming to PW6, Lordship.
PW?
6.
Yes.
On last 6/9/16, I was working as Sonari fuel station. From that a Bolero car with trucks came to Gohai Hotel. I went to so ASI so and one lady constable. Exhibit 4 ZD entry and exhibit 4 is my signature. We found the accused persons. We found drugs. The lady accused.
There is not a whisper about informing the superior officer.
Yes, it is there, Lordship. I informed the matter to a quarter DSP, Lordship.
Where?
Dear Lordship, relax.
So it's not reflected in the judgment.
That is dear Lordship. Exhibit, please.
Permission is to be in writing. Yes. So where is the writing? Has it been exhibited?
Lordship,
What is the time? What was the time
during daytime, Lordship.
during daytime? Before sunset? Even then, information is to be given in writing.
Lord.
Writing has to be exhibited.
Will you take us some time? We'll go through it.
US one estimate is very interesting. PW8. Along with the FIR authorization letter was not submitted by the informant. I was not present at the time of recovery of seized materials. And it is not in my case diary that whether any senior officer was present at the time of recovery. I did not record the statement of the witnesses. Then in the cross negi. In the last part, I did not record the statement of police constable section. When I received the drugs in the police station, they was not kept in any sealed packet. While sealing the packet, I did not obtain a signature of any witness at the time of sampling the drug.
Which PW you are reading?
PW 8. IO. Very interesting statement, madam. Cross part. When I received the drugs in the police station, these were not kept in any sealed packet. While sealing the packet, I didn't obtain the signature of any witness. At the time of sampling the drugs, no enemy witness was present.
IO himself says they were not in sealed condition.
42 and 52, both are blatantly violated. It's a severe case of acquittal, my lord. Actually, lower court held in a preceding that part.
Properly, Lordship, kindly.
You have to go through properly. You expect to find something.
Nothing is there anyway. Later try, my lord, but
All right, when do you want?
Dear Lordship.
when you tell us the sort that.
After vacation also. After vacation also.
No,
First week of January.
already 3 years he is suffering in jail for
This
nothing.
matter, commercial quantity, Lordship,
Whatever it is.
covered from the
You must
constitution
prove
of
that
the
it is sealed and sealed in proper manner in compliance with section 52
first week of
A
January, Lordship, any date.
my lord, let it be fixed on December. This she just wants to go through it properly, my lord. On 9th December, my lord.
Lordship, just after vacation, any date, Lordship.
No, then I have got the pending bail application, my lord. I'll press for that today. So they illegally detained a lady, my lord, for 3 years without.
Petition is from 21st.
Lordship.
So you don't need more than 10 days to go through it.
Then Lordship on 18th.
What is this? In December.
Yes, in December itself.
Okay. Let it demand pardon, madam.
But I'll not be available.
Third Lordship, it's a small matter.
Otherwise, man, it will remain in the list for. We are trying, breaking our head, man, last 2 months to reach the matter.
Then have it on 5th of December, no, of January.
It is too far, man.
Because I'll not be available from next week. Aizawl bench. For the
Okay, man,
remainder
let
of
it
the
be
year.
on, with the part of it, 18th December. 18th December.
18 December.
Yes.
No point in keeping it parted because I'll not be there.
Yes, you will not be here.
Call.
18th December, my lord.
Hmm?
18th December.
Yes.
Yes.
Obliged.
May it please your lordship. Here in this case, lordship, the appellant is convicted for 10 years, lordship. And here, one fact your lordship will see that incident occurred on lordship 25th. They said, lordship, the prosecution says that on the same day, they lost the FIR. So apparently there was no FIR, so I am not disputing that fact. There may be something, they have not lost the FIR on 25th. So on 26th, they lost the FIR. And on 25th itself, he was handed over to police. So for some reason, it was not recorded in the record by the investigating officer. He was forwarded on 26th morning, lordship. And medical was done on 27th. Now, what medical report says, lordship, medical report was done on 28th, lordship, at 11 p.m. night. And that says, lordship, she was subjected to sexual intercourse within 24 hours. By that time, the accused was already in custody of the police, lordship, from the record. And regarding, lordship, the time of occurrence, victim and mother says, lordship, at 10:30. Brother who comes subsequently, he says, lordship, I went to my house at 2 p.m. Then, lordship, accused came. Subsequently, that incident occurred.
The incident is of?
Incident, lordship, occurred. I'm giving the date, lordship. Incident occurred on, lordship, 25th. That date. I'm sorry, lordship. 25/4/2022.
25,
lordship.
4/2022. FIR is on?
26/4/2022.
You were taken into custody on?
As per evidence, I was handed over to police on 25th itself. Evidence of PW2, father who lost the FIR, lordship.
What about arrest memo?
Medical report, that arrest memo, and police also said that on 26. Even if we take, lordship, I was forwarded on 26, then also, lordship, medical was done on 28. 28/4/2022 at about 11:30 p.m. That is night. So if say the medical says, lordship, that within 24 hours, then from 27th, 11:30 PM, after that she was subjected to medical sexual harassment, lordship. And PW8, he is the brother of the victim. He says, lordship, he came to home at 2 PM and thereafter the incident occurred at 2:30 PM.